is Alan Gassman. It's Thursday, June 16th at 5:30 p.m., and we want to welcome all of you to our webinar entitled Helter Shelter, What to Recommend for Married Clients Whose Estate Planning Documents Provide for a Credit Shelter Trust on the First Death. I'm Alan Gassman, and I'm going to be assisted and actually led today by my partner, Crotty Denicolo, who has done a lot of work in this area. Chris and I have just finished publishing an article in the Estate Planning magazine on this topic, and we are going to send each of you a PDF of the article today so that you can take a look at it if you can bear to hear more about the topic. Now, I've got our picture on page 1, and it only gets worse from here. I'm going to go directly to page 4, and by the way, this is a PowerPoint that you have available for printing. If you have any technical issues or problems, actually I'm going to page 5, but if you have any technical issues or problems, you can call Janine at 442-1200 extension 8, and she'll be glad to help you out, or you can email Janine, Janine, at gassmanpa.com. Now, on page 5, I have the Protective Trust Logistical Chart. And this is what most of our clients have in their revocable trusts or sometimes in their wills as far as capturing assets on the first death which can benefit the surviving spouse but be protected on the second death and throughout the lifetime of the surviving spouse. So here you have the first dying spouse's revocable trust or a will. And on the death of the spouse, we can take the amount that passes estate tax-free, which is now $5 million, and put it into a bypass trust, or you may call it a credit shelter trust, that can benefit the surviving spouse without ever being subject to federal estate tax. Now, when I started practicing law in 1984, this allowance was $325,000. Then it went up to $600,000, then $675,000, then $1 million, then $1.5 million. Now it's up to $5 million. President Obama's February 2011 budget calls for this to come back down to $3.5 million. But a big question is, if we've drafted documents that provide by formula that the amount that passes estate tax-free will pass into this trust, is it now going to be overfunded? And is it now going to provide the provisions that we would like? You know, back in 1984, when I was drafting one of these, it was only going to hold $325,000 worth of assets, and maybe that was going to be held by a trust company that isn't even in existence anymore. Now it's going to be $5 million worth of assets, and I'm going to be more careful about how I draft this trust. Now, to give you a little bit more of the big picture, we normally use formula clauses which provide that the amount that passes estate tax-free will go into the bypass trust, and then anything above the amount that passes estate tax-free, we want to qualify for the federal estate tax marital deduction. So that would go to a Q-tip trust or a marital deduction trust or outright to the surviving spouse. And we prefer a marital deduction trust, or what we call a Q-tip trust, which stands for Qualified Terminable Interest Property Trust, because that will protect the surviving spouse from creditors and maybe from the surviving spouse's own imprudence and possibly even from some taxes, depending upon what the estate tax does in future years. On the second death, the credit shelter trust can go directly to children, or in the case of the family that I spoke with today, can divide into separate equal trusts for each of the children to be held for their benefit without being taxed in their estates. I really don't like leaving a lot of assets directly to a child. The child might get sued and lose them. The child might do something dumb with them and lose them, the assets. The child might lose them in a divorce, or the child might be subject to federal estate tax when they die. So we can leave these into a trust where each child could be their own trustee, or they could be a co-trustee. They can get what they need for health, education, and maintenance. They can spend it on their children. They can leave it to the descendants on their death and control how it passes to descendants, but it's much safer for the family in most situations. If this is in a credit shelter trust as a result of the first death, and it stays this way until the second death, then when the surviving spouse dies, there is not going to be a step up in basis. I'll tell you what I mean by that. Let's say the first spouse dies and leaves $2 million worth of IBM stock to the Credit Shelter Trust. That's going to get a basis of $2 million for income tax purposes when the first spouse dies. Now let's say when the second spouse dies that this stock is worth $10 million. And let's say that the capital gains tax in 30 years is going to be 30% because it was 28% under Ronald Reagan. So suddenly the family comes to my office and says, Alan drafted this Credit Shelter Trust to save my family taxes. This trust now has $8 million of capital gains in it. We're going to pay $2.4 million worth of taxes. What happened? And of course, I'll be here to say, well, you know what? We were trying to avoid estate tax, but there is no estate tax anymore. So I'm really sorry about the $3 million or the hundreds of thousands of dollars of capital gains taxes that you're going to have to pay now when you sell the when you sell the stock. So to cut to the chase, and Chris is going to give more detail on this, we are now putting a provision in our Credit Shelter Trust which allows a committee of trusted individuals or a trust company, somebody unrelated to the family, to give the surviving spouse a power to appoint the trust assets to creditors of the surviving spouse's estate. Now that's kind of silly. Why would you give somebody a power to appoint to appoint assets to creditors of their estate? And the reason is that if I do that, once the committee gives the spouse that power, then the spouse is considered to own those assets for estate tax purposes and income tax purposes, so they can get a stepped-up basis. So this way, we can have the family and their trusted advisors decide later up the road whether it's more important to have estate tax avoidance, if it even exists then, or income tax avoidance to get a step-up in basis. And that's one of the main messages of today's presentation and our estate planning magazine article. Now I'm going to trail back here to page 3. And on page 3, just so you have it, just so you know it's there, we give you the 2009 law, which is still the same for annual exclusion gifting of $13,000 a person. We remind you that clients can also pay tuition and medical expenses directly, and it doesn't count. And then the estate tax exemption, which went from $3.5 million to $5 million in 2011, and is scheduled to go down to $1 million only, January 1, 2013. Of course, nobody in Washington, D.C. seems to be agreeing on anything, so there's no telling what that's going to do. An estate tax rate that's now down to 35%, but scheduled to go to 55% in 2013, and this new thing, portability. Chris is going to talk a lot more about portability, but here's the question. It used to be that if I died first, I would want to put as much as I could into a Credit Shelter Trust so that my wife could get benefit of it without being subject to estate tax on her death. Well, now, if I die and I don't use my $5 million exemption, whatever part I didn't use is going to go to my surviving spouse. So if I have a $5 million exemption, my spouse has a $5 million exemption, and I die, she now has a $10 million exemption. Now, this law disappears January 1, 2013, but there's a good chance that it's going to continue. And if it continues, then there will be a lot of people who really won't be concerned about these Credit Shelter Trusts unless they realize that there's a lot of creditor protection planning, next marriage planning, and possible estate tax might be coming back planning. Now, if you want to have a little fun or you want to get a little bit of help trying to help a client what to do, you can go to our probability chart on page 4. We think there's a 70% chance that this $5 million exemption with consumer price index increases is going to continue. So we think that most clients probably aren't going to have any problem with estate tax and maybe need to start worrying more about income tax planning. But we think that there's a 10% chance that it could go back down to $1 million or somewhere above $1 million. And it sure wouldn't surprise me if in January 2013 that's what it does, at least for a few weeks while our heroes on Capitol Hill get their act together. 5% chance the exemption will come down to $3.5 million adjusted by CPI with portability. 10% chance the estate tax will be eliminated, in which case you don't want to unplug great-grandpa till January 1, 2013 if he's wealthy. And then a 5% chance that this gift tax exemption is going to go down to $1 million again, in which case people are going to be very happy that they gifted as much of the $5 million allowance as they could before they lost it. So many of our clients are now, in fact, I thought it was a 10% chance at number 2. Many of our clients are now looking at whether one spouse can make a gift of $4 million worth of assets to a trust to benefit the other spouse during her lifetime or his lifetime, and then the children without being subject to estate tax. And some of our clients are doing a full $10 million of gifting. And that's a generous thing to do, and you could also make that gift probably to a creditor protection trust where the client could actually be a beneficiary, still have it out of the client's estate, and the client has good business reasons, tax reasons, for setting up their creditor protection trust, and a great reason to write off their trip to Alaska or Belize or Nevada to meet with the trust company and their lawyer, who I have to go with them, to put this all together. Okay, I think I've given you the big picture now. I'm going to turn this over to Crotty Denicolo and let him start explaining page 6 and whatever other pages he'll be able to get to. Before I leave, though, I just want to make sure, and I'll be back at the end, but I wanted to make sure to mention that we recently published a book on this new law with B&A, and everyone who's attending this seminar live today is going to get a copy of the book in the mail, because we really appreciate you watching this and passing it on to your friends, clients, and colleagues. Chris?
Thank you very much, Alan. And just to follow up on what Alan's saying here, we have this new law that came out in 2010 that created a host of new areas of estate tax law that we've never seen before, one of which is this portability feature. And as Alan said, for decedents dying in 2011 and 2012, any unused federal estate tax exemption can be so-called ported to a surviving spouse. In that event, the surviving spouse can then use whatever's remaining after the decedent's assets would pass into this credit shelter trust or however else they're drafted to pass upon his death. Now, on this slide here, credit shelter trusts versus relying on exemption portability, despite this portability feature, we found that it's better to use credit shelter trust planning, and there's many reasons, some of which Alan had mentioned before. One of the primary reasons is that there's no portability for generation skipping tax exemption. So if the if the first dying spouse does not use all of his or her exemption and also does not use all of his or her GST exemption, then you would not be able to port this GST exemption to the surviving spouse to use on the surviving spouse's later death. By using a credit shelter trust, you can lock up these assets free of estate tax, and you can use the full amount of the generation skipping tax exemption on the first spouse's death. Another big reason why credit shelter trusts are preferable to portability is because there's no inflation component built into this portability allowance, whereas under the new law, credit shelter trust, the federal estate tax exemption of $5 million is tied to inflation, so that increases in the CPI would increase the amount that can pass estate tax free. So if we see rampant inflation or if the value of the dollar really decreases going forward, this credit shelter trust mechanism is more appropriate to lock in the benefits of that increased exemption with inflationary mechanisms. Another reason that Alan pointed out was the fact that you could lock up the assets in a credit shelter trust to protect the surviving spouse from his or her imprudence, creditors, future spouses perhaps, and of course, we don't know what's going to happen with the estate tax. So by putting it in a credit shelter trust, if the estate tax goes down to this $1 million amount, you have this amount that can pass free of estate tax on the second spouse's death, and that would certainly help to avoid estate tax. Now, this chart goes into more detail than what I've said, but in any event, it's worthwhile to consider both situations for each client, although credit shelter trust will often be the best choice you'll find. Okay, moving on to the next slide here. We're going to now talk more about credit shelter trust planning and some of the reasons why you may want to use this that I did not mention just for IRA planning and being able to stretch out benefits over multiple years. If you have a designated beneficiary in the credit shelter trust, that maybe wouldn't work if you just left it outright to the surviving spouse. Another thing to consider is whether charitable devices will be calculated or whether you want to put certain provisions or restrictions in instead of giving assets outright to beneficiaries or to the surviving spouse. Moving on to slide number 8 now, we have a chart that we've prepared for a client who had an IRA as most of his estate. And what we did was we broke down the IRA choices into three particular choices here. The first choice would be to leave it to the spouse outright. And to do that, you have the spouse named as the primary beneficiary of the IRA. The second choice would be to leave it to the deceased client's revocable trust, and you can name the revocable trust as the alternate beneficiary under the beneficiary designation. A third option, or a third beneficiary under the designation, could be an irrevocable trust for the benefit of the surviving spouse and the children, or in this case, just the children. And there's reasons, advantages for each and disadvantages for each, and this chart explains them. I don't want to get into much detail because I want to stay with the big picture here, but if you look at this chart, it might give you a helpful guidepost with planning for IRA benefits in light of credit shelter trusts and the new estate tax law. Okay, for slide 9, we have items here from our checklist that we put in this book that Alan mentioned earlier. And one of the main things is we want to maintain flexibility, and we want to have language in the credit shelter trust to combat future unforeseen circumstances regarding estate taxes and income taxes. For example, if the estate tax goes away and if income taxes are our primary concern, we want to have certain language in these trusts so that we can avoid income tax as opposed to estate tax. And as I move forward here to slide number 11, we have one of our choices that we can do to plan for this income tax planning and to get a step up in basis on the surviving spouse's death. And I'm having a little technical issue here with the slide. Oh, and here we are. The first choice would be just leaving assets outright to the surviving spouse, and then having the surviving spouse disclaim these assets into the credit shelter trust within 9 months of the deceased client's death. Now, the advantages of this are that it's very easy to understand, very easy to teach our clients and tell them how it works, and it's very easy to draft for. It simply just calls for creating a separate subtrust under the credit shelter trust of the decedent, whereby the surviving spouse wouldn't have the power to appoint the assets that flow to the trust as a result of the disclaimer. Another issue, or another advantage to this, with the surviving spouse can decide which assets he or she wants to own outright and which assets he or she wants to disclaim into this trust. It's very helpful, and often it's very easy to administer, and clients like that. But there are some downsides to this, and one of the downsides is the surviving spouse can appoint the assets in the credit shelter trust that come into the trust through the disclaimer. And that's just a big consideration for a lot of clients. Another issue is that the surviving spouse cannot distribute assets from the trust unless the distributions are tied to some sort of ascertainable standard. And that could be troublesome in some situations. It shouldn't be as big of a deal as the power of appointment prohibitions. But in any event, this choice is something that can accomplish this income tax planning objective, but it's limited in some cases here, and there are much better alternatives, as we'll get to. At the next slide, we get into the second choice here. I'm sorry, slide 13. The second choice involves having special trustees of the credit shelter trust be able to distribute assets outright to the surviving spouse. This is probably one of the least preferred alternatives, and simply because the assets that are distributed out to the surviving spouse are not exempt from his or her creditors. They would be included in his or her estate, as we would like to do here, but it's something where it's not protected, and you're kind of really not taking advantage of this credit shelter amount on the first dying spouse's death. There's fiduciary duty issues here as well, and it seems like this is one of the alternatives that we would address last, although it is very simple to administer and easy to understand and to teach to our clients. I'm going to jump ahead 2 slides now to slide number 15. I'm sorry, slide number 16, 3 slides, and this involves what's called the Clayton Q-tip arrangement. And for those of you who aren't aware of what a Clayton Q-tip is, essentially is a trust that qualifies as a Q-tip trust, but only because the personal representatives of the decedent's estate can make the Q-tip election when filing the decedent's estate tax return. It's called the Clayton Q-tip because there was a case back in the 80s in which the IRS lost, called Clayton, and ultimately there were some regulations under Internal Revenue Code 2056 that allowed this type of procedure. This is a very, very helpful mechanism. It's very difficult to explain to clients who aren't learned of these topics. One of these issues as well with this mechanism is that it's going to have the Q-tip assets included in the estate of the surviving spouse, which could be problematic if we don't have portability in existence at that time. And it's, like I said, it's very complicated, but it works very well if the family's better off taking the marital deduction up front, and if we know portability is going to be around. It seems like it's something that's kind of complex, and we still don't think it's the best alternative. And as Alan mentioned earlier, this fourth alternative here on slide number 17 is our preferred alternative. I'm sorry, it's slide 19 actually. And what that is having a committee having a committee with the power to give the surviving spouse a general power of appointment, giving the surviving spouse the power to appoint the assets to the creditors of his or her estate. And what that does is allows the assets to be included in the surviving spouse's estate for estate tax purposes, which in turn allows a step up in income tax basis. So as Alan pointed out earlier, if you have low basis stock or low basis assets that explode in value and the estate tax has disappeared or has become less of a threat, then this committee can bestow this general power of appointment on the surviving spouse. The surviving spouse can take can have the assets included in his or her estate. The assets would receive a step up in income tax basis, and they would avoid income tax more so than estate tax. And it can be very helpful, and it's something it's very helpful just to have in your documents, because just having the committee there does not automatically include the assets in the surviving spouse's estate. If the committee is independent, and if the committee is not a beneficiary of the trust or related to the grantor, we don't think that it's going to have any problems and definitely cause inclusion in the surviving spouse's estate. It's something that should be considered. And on the next slide here, slide 20, we have some sample language that can be included, and it's something it's very helpful, as I pointed out. One downside with the Clayton Q-tip as opposed to this is that the Clayton Q-tip and also the disclaimer strategy are both tied to time limits. The disclaimer must be made within 9 months of the first dying spouse's death, while the Clayton Q-tip election must be made within 15 months of the deceased spouse's death. This general power of appointment committee is not tied to a time limit. They can add this power of appointment at any time during the surviving spouse's life, and that's very helpful here. And seeing as how the estate tax law seemingly changed overnight, and this new law came out with very little notice, it's worthwhile to have that kind of flexibility built into your documents. There is a fifth alternative here on slide 22 that I want to address, although it's very limited in application and it may not be helpful. It's called the Delaware tax trap, which has been the bane of many lawyers who are studying for the bar exam or for the board certification exam. It's something where if you have a general power of appointment, a limited power of appointment in somebody, and they exercise that to create another limited power of appointment in somebody to extend this perpetuities period, then that's going to cause the assets to be included in the first power holder's estate. It's a very complex area of law. It's very difficult to explain to clients, and a lot of states have come out with statutes which would prevent extension of this perpetuities period. So this is almost ineffectual in a lot of jurisdictions. In Florida, of course, we're usually on the cutting edge of legal trends here. We do have this provision that prevents Delaware tax trap from applying. It's a very archaic notion of law, and it's something that I wanted to point out, although it's very limited in its practical application. And we have some some language here in more detail on slide 23. You can look at that if you like at some point in the future. On slide 24, we'll talk about resituating assets and retitling assets to make full use of each spouse's $5 million exemption, or in most cases, to facilitate full funding of a credit shelter trust on the first dying spouse's death. And before, we did a lot of structuring where we had to make sure that each spouse had equivalent assets to fill up their credit shelter trust. But portability has mitigated these concerns to some extent, but we still have to make sure that there's at least $5 million worth of assets, if that many assets exist, in the first dying spouse's estate that can fund this credit shelter trust. On slide 26, we have this chart here which shows how we might structure some assets with tenants by the entirety's ownership, or with irrevocable trust and life insurance. Because of the time constraints, I'm just going to skim through this here, but it's something I did want to point out. I think slide 27 here also has ideas on how to structure assets to make full use of this $5 million exemption on the first dying spouse's death. Okay, on slide 28, we have some estate and asset protection planning for single professionals, which, this is about married clients here, this presentation, but we do want to remember single clients also have to have their affairs structured so as to take advantage of the new law. And this is a chart that you can share to single clients and use and help for planning for your single clients here. I'm going to skip ahead to slide 29 now, which addresses a couple more issues here that we can take advantage of, and ideas we can take advantage of for these, as Alan calls them, the $5 million bump years of 2011 and 2012, where you have this increased estate tax exemption. The first issue we talked about previously, we want to make sure that there's at least $5 million worth of assets under each spouse's revocable trust to make full use of the estate tax exemption to the best that we can. Another issue to consider there under letter C would be using a joint trust and giving each spouse a full general power of appointment on the death of the first dying spouse, so that a credit shelter trust would be funded regardless of who dies first. It's certainly worthwhile to consider this when you have married clients. Another idea would be considering adding term or other life insurance to make best use of the first dying spouse's exemption, especially if the higher income earner or inheritor needs these assets to facilitate full funding of the credit shelter trust. And I think that wraps up the crux of our presentation. I'm going to pass it back to Alan for some closing remarks.
Well, Chris, that was excellent. I think you did a great job covering what should be a simple topic. And those of you who have listened to this presentation, if you think through how to best handle the discussion of this with clients, we suggest that you consider our Estate Planning Magazine article, which goes through an actual conversation by a professional with some very smart clients, and what the clients are thinking and what the professional is thinking. Again, we really appreciate your participation in this webinar. If you want to email us any questions, if anyone's still awake, we'll be glad to answer them. We're going to send each of you a free copy of our B&A book because we really appreciate your interest. And have a fantastic evening. It is 5:59 p.m., almost the cocktail hour. Good night.